Law of Contract, presented by Group 5.
What is the law of contract? The law of contract is concerned about the legal enforceability of promises. In that context, a contract may be described as an agreement that the law or the courts will enforce. This notion of enforceability is central to the contract law. If you break or breach the contract, the other party has several legal remedies.
For example, after signing the contract agreed by the first and second parties, if one of the parties violates the previously agreed contract, then the other party can claim compensation or cancel the contract.
There are many principles law of contract such as offer, invitation to treat, acceptance, intention to create legal relation, capacity, consideration, discharge of contract, remedies, void and unlawful agreement. Offer is something which is capable of being converted into an agreement by the acceptance of the offer. A proposal or an offer must be a definite promise to be bound provided certain specific terms are accepted. The promiser must have declared his readiness to undertake an obligation upon certain terms, leaving the option of its acceptance or refusal to the offer.
For example, Putri is thinking of buying a motorbike. Dewi comes to Putri and offers the motorbike to Putri.
Acceptance. Agreement comes into existence when an offer is accepted. The acceptance must be made while the offer is still in force. In example, before it has lapsed, been revoked or rejected, acceptance is thus only possible if the offer is still in force. Once the acceptance is completed, the offer becomes irreversible.
For example, Putri sees the motorbike and accepts Dewi's offer.
Intention to create legal relation. An agreement is not a binding contract unless the parties intend to create legal relation. If parties indicate that they do not wish their agreement to be binding on them, the law would respect their intention. Although the Contract Act is silent on the intention to create legal relation as one of the requirements of a valid contract, case law clearly dictates the necessity of this requirement.
For example, Putri take care of motorbike purchase contract between Putri and Dewi. Consideration.
When, at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstains or promise is called consideration for the promise.
For example, Putri is considering buying a motorbike like number, motorbike, motorbike engines, and etc.
Void contracts. A void contract is an agreement not enforceable by the law of the Contract Act. Said Act provides that the consideration or object of an agreement is unlawful if it's law within any of the subsection or of the section. Unlawful agreements. Some agreements are merely void, but others can be void as well as unlawful. In the latter group, the parties concerned are treated more strictly by the law. A court will refuse to enforce it. The Contract Act does not appear to have provided specifically for illegal contracts. They are classified as void contracts.
Example of void contract and unlawful contract is Putri canceled the contract because the motorbike is illegal or the engine is broken and another reason. That's all the explanation about principal law of contract from group 5. Thank you. See you next video. Bye.